from Criminal Liability Article 11. Justifying circumstances. The following do not incur any criminal liability. Number 1. Anyone who acts in defense of his person or rights, provided that circumstances: first, unlawful aggression; second, reasonable necessity of the means employed to prevent or repel it; third, lack of sufficient provocation on the part of the person defending himself. Anyone who acts in defense of the person or rights of his spouse, antecedents, descendants, os legitimate, natural, or adopted brothers or sisters of his relatives by affinity in the same degrees, and those by consanguinity within the fourth civil degree, provided that the first and second requisite prescribed the next preceding circumstances are present, and the further requisite in case that the provocation must given by the person attacked, that the one only making defense had no part wherein. Anyone who acts in defense on the person or rights of a stranger, provided that the first and second requisite mentioned in the first circumstance of this article are present, and that the person defending be not induced by revenge, resentment, or other event motive. Number 4, any person order to avoid evil or injury, thus an act which causes damage to another, provided that any that the following requires that the request are present: first, that the evil sought to be avoided actually exists; second, that the injury feared be greater that than to avoid it; third, that there be no other practical unless fulfillment to preventing it; 5. Any person who acts in the fulfillment of a duty or in the lawful exercise of a right of office. Number 6. Any person who acts in obedience to an order to issued by superior for some lawful purpose. Article 12. Circumstances which attempt from the criminal liability. Following are except from criminal liability. Number 1, an imbecile and insane person, unless the latter has act during a lucid interval, when the imbecile or an insane person has committed an act which the law defines as a felony. The court shall order his confinement in one of the hospitals and installments established for person those affected, which she shall not be permitted leave without first obtaining the person of the same court. Number 2, the person under 9 years of age. Number 3, a person over 9 years of age under 15, unless she has act with discernment, in which case such minor shall be proceeded against in ordinance with the provision of the Article 80. of this code, which, when such minor with a judgment to be criminal liability responsible, the court in conformity with the provision of this and the preceding paragraph shall commit him into the care and custody of his family, who shall be changed with his surveillance and education. Otherwise, he shall be committed with the care of his some institution or person mentioned in said Article 80. Number 4. Any person who, while performing a lawful act with due care, causes an injury by mere incident without fault or intention of causing it. Number 5. Any person who acts under the compulsion of an insurmountable force. Number 6. Any person who acts under the impulse of an uncontrollable fear of an equal or greater injury. Number 7. Any person who fails to perform an act required by law when prevented by some lawful or insuperable cause. Chapter 3. Circumstances which mitigate criminal liability. Article 13. The mitigating circumstances. The following are mitigating the circumstances. Number 1. Those mentioned in the preceding chapter when all all the requisites necessary to justify the act of to attempt to criminal liability in prospective cases or unattended. That the offender, number 2, that the offender under 18 years or 70 years. In the case of the minor, he shall be proceeded against in accordance with the provision of Article 80. Number 3, that the offender had no intention to commit to grieve a wrong has committed. Offended party immediately act. Number 5, that the act was committed in the immediate vindication a grave offense to the committing the following: felony his spouse, accidents, decedents, legitimate, natural, or adopted brothers or sisters, or relatives beneficially by the same degree. Number 6, that of having acted upon an impulse so powerful as naturally to have produced passion or advocation. Number 7, that the offender had voluntarily surrendered himself to a person in authority on his against, or that he had voluntarily confessed his guilt before the court prior to the presentation of the evidence for the prosecution. Number 8, that the offender his death undammed or life otherwise suffering some physical defect which those restricts his means of action, defense, or communication with his fellow beings. Number 9, such illness of the offender as would diminish the exercise of the whole power of the offender without, however, preventing his consciousness of his acts. Number 10, and finally, any other circumstances of a similar nature and analogous to those above mentioned. Chapter 4. Article 14. Aggravating circumstances. Number 1. The advantage be taken by the public position. Number 2. That the crime be committed the contempt of the or with or insult to the public authorities. Number 3. That the acts be committed either with insult or in disregard of the or 6. That is committed in the drilling of the offended party if the latter has not given provocation. Number 4. That the act be committed with abuse of confidence or abuse ungratefulness. 5. That the crime be committed and the committed be placed the chief executive or in his presence, or where public authorities are engaged the discharge of their duties, or in a place dedicated to religious worship. Number 6. That the crime be committed in the nighttime or an inhabited place or by and never such as circumstances may facilitate the commission of the offense. Whenever more than 3 and malefactors shall have act together with a commission of an offense, it shall be death to have been committed by the band. Number 7. That the crime be committed on the accused, or a flood, conflagration, shipwreck, earthquake, epidemic, or other calamity or misfure, that is crime. 8. That is crime be committed with the aid of armed men or person to ensure or afford opportunity. Number 9. That the accused is a recidivist is one who at a time of his trial for one crime shall have been previously convicted by final judgment. Another crime embrace the same title of this code. Number 10. That the offender has been previously punished for an offense to which the law attach an equal or greater penalty, or for or 2 or more crimes to win attach a lighter penalty. That the crime be committed in consideration of a price, reward, or promise. Number 12. That our crime or committed by means of inundation, fire, or furto or fire position, explosion, streading, or real vessels or intention damage. Terror, elements of documented by the use of any others. Article enterprise involving waste and ruin. Number 13. That the act be committed with the evident remediation. That number 14. That craft period or degrees be employed. Number 15. That the advantage be taken of superior strength or means be employed the weaken the defense. Number 16. That the act be committed with treachery. There is treachery within the offender commits any of the crimes, employing means, methods, or forms in the execution thereof, which tend directly and especially to ensure his execution without risk to himself arising from the defense which the offended party may meet. That means that employ the circumstances brought about which aid ignominy to the natural effect of the act. Number 18, that the crime be committed after unlawful entry. Where is an unlawful entry? When an entrance effected by a way not intended for the purpose. Number 19, as a means of the wall, crime, floor, door, or window broken. Number 20, that the crime be committed with the aid of a person under 15 years of age or by means of motorcycles, airships, or other similar means. That the wrong done in the commission on the crime be deliberately aggravated by causing other wrong not necessary for its commission. Chapter 5, Article 15. Their concept are alternative circumstances are those which must be taken into consideration as aggravating or mitigating according to the nature or effect of the crime. On the other consideration, attending ignition, they are the relationship, execution, on the degree of instruction or uneducation of the offender. The alternative circumstances of relationship shall be taken into consideration when the offended party is disposed, antecedent, descendants, legitimate, natural, or adopt brother or sisters or relatives by infinitely the same degree of the offender. The extoxication of the offender shall be taken into consideration as mitigating circumstances which the offender has committed the felony in a state of extrication if the same is not habitual or subsequent of the plan to commit felony, but when the execution is habitual or intentional, it shall be considered as an aggravating circumstance. That's all, ma'am. Thank you.